Bad news. Bad news. If you're watching this video, you could have some bad news, because this video is what to expect at your arraignment in Washington State. The good news is that I'm Lance Fryrear, defender of justice. And I'm here to explain to you what to expect at your first criminal appearance on a criminal charge in Washington State. And that first criminal appearance is called an arraignment. So first, how did we get here? Well, if you're worried about going to an arraignment, you were either given a citation by a police officer or you received a nastygram in the mail, a criminal complaint with a summons, and the summons is usually sent to you by the court after the prosecutor sent a criminal complaint in against you, charging you with some type of crime. Usually you're going to have about 2 weeks before you have to go to your court date. And most people really don't use that 2 weeks effectively. And I'm here to tell you that you should. So what should I expect at my arraignment when I go to court in Washington State? Well, let's just pretend your court date has come up. You drive to the courthouse. It's 9 a.m. at South District Court in Lynnwood, or it's 1 p.m. at Seattle Municipal Court in Seattle. And you find your name on the list, you go to the courtroom, no big deal. You get there, you're by yourself. All of a sudden now there's a prosecuting attorney there. And there's a court clerk and a judge, and eventually your case gets called. And so you're going to step up to the desk where you're supposed to stand as the defendant. You might be a little nervous, and the court's going to say, okay, Mr. Defendant, Ms. Defendant, you are accused of DUI, or you are accused of domestic violence assault. How do you plead? And of course, hopefully you're going to say, not guilty, Your Honor. And then the court's going to set a court date for you, and you just get to leave, right? Well, that's part of it. And that's why so many people don't take arraignment seriously. You need to take it seriously because the court is required to set conditions on your continued release at that arraignment date. And there's a prosecutor there, 9 times out of 10, there's a prosecutor there, and they may ask to take you to jail that day. They may ask to put you in jail for bail or bond because either they claim you're dangerous or they claim you have a history of failing to appear for court. And you need someone to be able to tell the court that that's not so. What type of conditions might the court set? Well, on a domestic violence assault case, you're going to have driven to court, and the court's most likely not going to let you drive home. Because on a domestic violence assault case, the court's going to usually issue a no contact order saying you can't have contact with the alleged victim. And let's face it, usually on a domestic violence case, it's our boyfriend or girlfriend or husband or wife or roommate, brother or sister. Someone that we live with is usually the victim. And we can drive to court expecting that we're just going to say not guilty. We oftentimes don't expect we're not going to be able to go home. And that is a total nightmare. On a DUI, the court may order you to impose an interlock where you have to blow to start your car. The court may also impose a scram bracelet where you have to be monitored like Lindsay Lohan 24/7 for alcohol. That happened to her, I think, back in the day. That is not any fun. Some of our clients have told us about having that. It vibrates in the middle of the night. You wake up the whole time. And so these things are to be avoided. And so it's really important you don't waste your time between the time you have the notice and the time you go to court. You need to do your research, and that's what you're doing now. Typically, you want to either get yourself an attorney to help argue this for you, or get a hold of a public defender, see what the application process is. Hey, court, am I going to have an attorney there with me automatically? Do I need to apply ahead of time? And that varies court by court. Now we can talk about something more serious. What if you have an arraignment for a felony matter, a serious matter, like knocking off a liquor store? Now, do not knock off a liquor store. That is not a good thing. But if you're accused of knocking off a liquor store, then when you go to court, the court almost certainly is going to set bail on a violent offense, a felony assault, a robbery, that type of attack on a business, because that's defined as a violent offense under the law. And you may walk into court with your freedom, and you may have to post bail or bond to maintain your freedom later. And we talk about bail or bond in another video. You can look for that if you want. But it's important that you're prepared for that arraignment, because you do enter a plea of not guilty, You do usually get a new court date, but also conditions get set that can affect you for the next 3 months, 6 months, even a year. Cases take a long time to resolve. So it's important that you're prepared. So if you have a criminal charge against you, you've got an arraignment notice, and you need more legal advice, you can always contact us if you want. My name's Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We've been serving Lynnwood for over 20 years. I think we've represented a little over 5,000 clients on criminal matters. And this is not a pitch for you to hire us. This is more informational video. I hope you find it useful. But I always just want to let everyone know that even if you just have questions, you can give us a call. Our phone number here is in this video, and we'll do whatever we can to help. As we tell all of our clients, we'll be there for you. Thank you.